Good morning, everybody. My name is Shari. I'm a managing attorney at Disability Rights Pennsylvania, and this is my co-presenter.
I'm Bob Corcoran. I'm a CPA and financial advisor here in the Pittsburgh area.
We've divvied up the presentation, so I'm going to go first and talk to you a lot about transition planning with regard to decision making, in particular with healthcare. And then Bob is going to pick up and talk about financial planning as well.
Yeah, and those two things are joined at the hip, but we'll divide and conquer today. So
great. All right, so if you're attending this conference this morning, there's a good chance that you are a parent or have someone in your life who is transitioning. And if you have somebody who's about to turn 18, that's the legal age for becoming an adult in Pennsylvania. So that's a very exciting time, but it can be a little bit scary as well. There's lots of decisions coming up. There's lots of transitions coming up. And transition planning is critical in all components of your child's life. So think about school. Are they ready to graduate, right? Do they have the services and supports they need in their IEPs at school, including transition planning to take the next step after high school? Is that going to be employment? Is it going to be post-secondary education? Do they have the resources and supports they're going to need? Are they going to need reasonable accommodations in school or at their job? Are they going to be able to live independently, move out of the family home and either live completely independently, or are they going to live in some sort of position where they're going to have supports and services so that they can function and become productive and happy members of society? And then, of course, the financial piece, which Bob will cover in his session, which is what's going to happen, is your loved one, is your child going to have the resources that they need financially to continue to live a good life when you're no longer around, to make sure that that's going to happen. So we're going to touch on all of those things. Our goal today is really to provide you with information, advice, and resources to help you support your child to achieve independence and self-fulfillment as they transition to age 18 and beyond that. As I mentioned, I work for Disability Rights Pennsylvania, and Disability Rights Pennsylvania is a resource for families. We can help you with some legal advice. We can also help you with self-advocacy assistance so that you can help advocate for your child who's transitioning, and more importantly, that your child can learn to self-advocate for themselves as they reach adulthood. Disability Rights Pennsylvania is the federally mandated protection and advocacy agency in Pennsylvania, and we have been that designated agency for the past 45 years. We work to advance and protect the rights of all people with disabilities, children and adults, so that they can live in the communities, their own communities, with the supports and services they need, free from abuse, neglect, exploitation, and discrimination. We have an intake helpline that you can call us Monday through Friday and talk to somebody if you have a disability-related question. And if we're not able to answer it, we can certainly, in most cases, point you to another social service agency or some other type of resource that can help address and potentially solve your problem. Now, of course, we can't cover all the critical transitions that your family will want to plan for today, but we're going to focus on the legal and practical concerns around decision-making in the areas of healthcare and financial planning. And when we talk about decision-making, we first need to understand the freedom of adults to make decisions, which I think we all take for granted. Anybody who's reached adulthood, we do our own thing. We make our own decisions. We don't really think much about it. But we all have the right to do that, right? And I did a quick Google search before coming today, and there's multiple sources that claim that the average adult makes about 35,000 decisions per day, which kind of blew me away, right? So 35,000 decisions. So some of those, of course, are just routine. We don't really think much about them kind of decisions. Some of them are simple decisions like, what am I going to wear today? What am I going to eat today? What are my activities going to be today? And then, of course, there are others that have more significant and more long-lasting consequences, like, what relationships do I want to be in? Do I want to get treatment for a certain illness? How am I going to invest my money, my savings account? How am I going to invest my inheritance, whatever those are? Historically, people with disabilities were presumed not to be able to make any of those decisions. Most people with disabilities used to grow up or live in institutions which were segregated from other people who did not have disabilities. And decision-making in institutions is not really necessary at all. when you get up, when you go to bed, what you eat, what you're going to wear, those things are typically decided for you. So there wasn't a real need for people with disabilities to make decisions on a daily basis. But now today, integration is the norm. And most people with disabilities are going to live their lives in their communities with supports and services. And so consequently, decision-making for people with disabilities is now a higher issue of concern. Who makes decisions, how they're made? It's important. It's important to understand how that happens. And we're going to talk about that. But to understand how to consider those things, we're going to need to talk about some legal underpinnings around decision-making first. So adults, even adults with disabilities, have the right and are presumed to have capacity to make their own decisions. And the freedom to make decisions is fundamental to personal autonomy and self-determination. But an adult's right to make their own decisions can sometimes be limited. People with disabilities may need supports to help them understand and make decisions, and often a supported decision-making model is going to be effective in those situations. Sometimes, however, people with disabilities might need others to make a decision for them. And these are often called substitute decision makers, and we're going to talk about that as well. Consent and capacity are really the key issues that inform questions about decision making. So whether an adult has capacity to provide consent is usually determinative of whether they can make their own decisions. So what does that mean? Capacity to consent means that the person possesses the ability to understand the situation, the alternative options, and the risks and benefits that are associated with those choices, and then possesses the ability to use that information in a logical and rational way to reach a decision, and then to communicate that decision to a third person. So either verbally or in some other means of communication, as long as it's effective. So that's capacity, and the capacity to provide consent in a specific situation will oftentimes depend on what the situation is and whether the consent that's required is going to be a simple consent or an informed consent. So simple consent is adequate usually for decisions that relate to routine matters, and that really don't pose a high risk of harm greater than you encounter in everyday life. So again, what am I going to have for dinner? What outfit am I going to wear? What activities do I want to engage in? Things of that are usually simple consent. Most people have capacity to make a lot of those decisions. Informed consent is necessary for decisions that have a greater risk of consequences than those we typically encounter in our daily life. So should I get medical treatment for a complex illness? Should I consent to invasive tests? Should I consent to surgery? Should I buy that car or that house with this that's going to cause me a lot of money and probably a lot of loans? Those types of decisions require a higher level of consent, and therefore capacity will be gauged on that type of decision. So I want to say that most people with disabilities, including people with intellectual disabilities, autism, traumatic brain injury, a lot of people can provide simple consent to day-to-day decisions, either with support or without support. And a diagnosis of intellectual disability or autism or dementia or traumatic brain injury or any other cognitive disability doesn't necessarily mean that the person lacks capacity to make all decisions. And so remember, we make about 35,000 a day. So it's not an all or nothing kind of deal. If you determine that a person with a disability does not have the capacity to make a decision in some context because perhaps it requires a higher level of consent, there's really two legal frameworks that come into play that we want to talk about today. There's substitute decision-making, which is a decision that's made for another person, not by them or with them. It's actually a person, the model gives a third person the ability to come in with the authority to make decisions for somebody else. And therefore it takes away the authority of the individual from being able to make their own decision in that framework. Now, there's lots of forms of substitute decision-making, including guardianship, which I know a lot of families are sort of curious about and wondering if they need to pursue that avenue. And we're going to talk about guardianship, but that is just one form of substitute decision-making, and it's actually the most restrictive form that there is. On the other side, there is supported decision-making, which recognizes that we all make decisions with support of others every day. we have family, we have friends, we have professional support, we have colleagues, we have neighbors, people who help us to think through a situation, understand choices, and then come to a decision. And so supported decision-making allows an individual, even an individual with a disability, to retain their legal ability and their legal authority to make decisions, but with the appropriate supports in place to help them along. So again, the key is the individual retains the ultimate decision-making authority. They don't give that to somebody else, or it's not taken away from them. So obviously, supported decision-making is more respectful for individual autonomy than substitute decision-making is. The elements of supported decision-making would include a network of people who have an established trusting relationship with the individual. And I've heard a lot about that this morning. You know, we talk about care teams, right? Nobody's making unilateral decisions without input from other. We have teams and groups of people and networks of people that are working to make transition successful and productive for the patients in the hospital. And this also applies in other areas of life. And in addition to a network of people that have a trusting relationship, those folks are to help provide information to the individual who has to make the decision in a way that they can understand it. So sometimes that just means talking in plain language to somebody, or maybe communicating in a different format that they're able to understand more effectively. As long as the communication is effective, it empowers the individual to understand that information and then use that information with a network and support to make a decision. Sometimes people also might need accommodations to make a decision. So if somebody has a disability, cognitive impairment, for example, they might just need a little bit more time to process information and make a decision. But ultimately, again, it's the individual with a disability who gets to make the decision in that model. Interestingly, in Pennsylvania, we don't, under the law, recognize any formal supported decision-making framework legally in Pennsylvania. Some states do, and they do have state laws that apply and explain how it works. We don't actually have a law in Pennsylvania for supported decision-making, but it does have relevance in Pennsylvania. There's an example, there's a Supreme Court of Pennsylvania case called In Re Peri, where the Supreme Court held that the availability of natural supports in a person's life who lacked capacity to make some higher level decisions was enough to stop a guardianship. Because if you have that network of supports, it's an alternative to guardianship, and we'll talk more about that. So it does have some relevance here. It also has some relevance in the disability services system once children transition to adulthood and they transition out of school, and now they're looking for supports and services from outside systems that are not their school. They move from an IEP, an individualized education program, to an ISP, which is an individualized supports plan in a lot of those programs. And that is a person-centered process, which again includes involvement of a trusted network of people. So family, friends, advocates, professionals, anybody that the individual would like to invite to that meeting serves as a network to help make decisions about care and treatment of that individual, supports and services they'll need as they're in adulthood. And of course, like I said, we all use natural supports in some ways. Everybody, including people with disabilities, uses those natural supports on a daily basis to make decisions of all kinds. There's limits to this supported decision-making model, of course, because it's not going to be effective, for example, if the person with the disability doesn't want help from those people, right? So it's not going to work in that situation. Or it's not going to work if there's a situation where a person has already a legally appointed guardian or somebody who has authority to make decisions in their place. In that case, they're not going to be able to use this informal supported decision-making model. And sometimes it might be the type of decision that really doesn't lend itself to supported decision-making, and perhaps a substitute decision maker is going to be necessary. So that could be true in healthcare in some contexts. If it's a decision that's going to have a high risk associated with the potential benefits, it's probably going to require somebody with legal authority to make that decision if the person themselves doesn't have capacity to do it. And in some financial situations as well, oftentimes banks are usually going to want a substitute decision maker with legal authority if a person doesn't have capacity to make financial decisions. So it's not the solution to all problems, but it is a definite framework to consider. And again, given the amount of decisions that we make in everyday life, it could be a really good fit for a lot of those decisions. But as I mentioned, substitute decision-making grants decision-making authority to another person, and comes in many forms, including guardianship. So what I want to say first, before I say anything else about guardianship, is legal guardianship should only be considered as a last resort, despite the fact that I think a lot of families and parents of children who are transitioning and becoming adults are pointed in that direction. I think there's, it's not from bad intent, but I think there's a lot of misunderstanding from a lot of different areas that touch people's lives about guardianship and when or if it's ever necessary. So even if you've been told by your kid's teacher or even a doctor or a lawyer in some respect that you have to get guardianship, take a breath and think, let's exhaust and see if there are other less restrictive alternatives that might work in any particular situation before we do guardianship. Guardianship is a legal document, right? You have to go to court and you get a court order that defines the guardianship for you. There's a definition under the law of what it means to be legally incapacitated that you have to prove in a court of law in order to get a guardianship order from a courtroom. And again, when I mentioned earlier that Supreme Court of Pennsylvania case in Re Piri, which was a guardianship case, the court didn't award guardianship because the individual who was subject to the petition had a network of people that were there to support and help guide the person. So it's not always necessary. It's time consuming and it costs money. When you're talking about going to court, it's expensive. You're going to have a lawyer, or you're going to want a lawyer in most cases. You'll probably need an expert to talk about the capacity and the finding of capacity. Even if you're appointed a guardian, there's annual reports that have to take place. There's filing fees. So it's not quick. It's not inexpensive. It is burdensome. And it is the most restrictive form of, decision-making in to take someone's rights away. Guardianship really completely removes whatever rights are granted to that third party from the individual. So, and sometimes it can also cause problems within families if you have families fighting about who should be the guardian. So it's not always a great solution. Even in cases where it might be the solution and it might be the need is there, the guardianship law in Pennsylvania recognizes that everybody has unique needs, and incapacitated persons, after they have been found to need a guardianship, still are supposed to participate fully in as much as possible in decisions that affect them. So simply becoming someone's guardian doesn't mean that the person gets erased from the equation. They should still have input, and they should still be trying to advocate and communicate their wants and needs during that process. There's different types of guardianship. There's guardianship of the person. There's guardianship of the estate. There's different scopes of guardianship. There's plenary guardianship and limited guardianship. All of these things factor in as to what powers a guardian has. A guardian of the person, for example, does make decisions about care and maintenance of the person, including where they live, what types of health care they might get. Guardian of the state is going to work with the person's money to make sure that they are handling their income and assets appropriately. So all of those things are given by court order, and I'm not going to spend more time talking about that other than, again, just to sort of say, don't consider it as a first option, think of it as a last resort. And there are some limitations to guardianship as well. They don't have complete ultimate authority to make all decisions. So just keep that in mind as well. It's, again, not a solution to every problem that a person might ever face in their life. So what are some alternatives to guardianship to consider before you go down that path? Well, supported decision-making, as we've talked about, is a great model for a lot of decisions that don't require a real high level of informed consent. When you do get to the point where you're going to need maybe a substitute decision maker and you want to look outside of guardianship first, in the healthcare respect, we have healthcare advanced directives, and we're going to talk about those a little bit more. There's also a tool called healthcare representative, and I'm going to touch on that as well. There's also, in the mental health area, we have mental health advanced directives, which can also help a person have autonomy while they still have capacity to make decisions and appoint somebody to speak for them if and when they become incapacitated due to a mental illness. And even if people with disabilities are placed in settings where they're in a program or a living arrangement that's operated by providers, there's a law that allows sometimes providers who are custodial caregivers for people to help make decisions in some situations without the need for guardianship. So there's a whole bunch of tools. I'm not going to touch on the financial tools. Bob's going to cover those in his session, but there's also a lot of ways for financial support without guardianship that Bob will talk to you about during his presentation. I'm just going to focus mostly for the rest of my minutes on healthcare decision-making and advanced directives that can potentially be helpful for people. In 2006, the Pennsylvania enacted what's called the Healthcare Agents and Representative Act, which is commonly referred to Act 169. And that governs healthcare advanced directives. So I'm talking about, when I say advanced directives, healthcare power of attorney and living will, or a combined document that covers both of those things. Anyone who's 18 or older and who is of, quote, sound mind can execute an advanced healthcare directive. So what does that mean? Sound mind, love that term, right? Sound mind means basically the ability to make an informed decision about the matters that would be covered by the advanced healthcare directive. So if you want to have a healthcare power of attorney, let's say I want to make a healthcare power of attorney, so I would be the principal and I want to appoint Bob as my agent. So he's going to make healthcare decisions for me if and when I don't have the capacity to do that for myself. If I understand the document, the authority that I'm giving him and what's contained in that document, I have sound mind to do that. I've made the choice. I understand what I'm doing. I understand what I'm telling him he has the authority to do. That's what that means. Some individuals with disabilities have that ability. And so doing something like creating a healthcare power of attorney to have somebody speak for you when you are no longer have the capacity to do that is great. And they should be encouraged to do it. Even people with cognitive disabilities. Again, there's a great variation in how people can process information. Somebody with autism might have a cognitive impairment, but still have the ability to understand a healthcare power of attorney or a living will. So we should never rule out the possibility of doing advanced healthcare directives for people with disabilities. It will really just be dependent on what their capacity is in any given situation. So healthcare power of attorney gives somebody the agency to make decisions. It's a great tool to do that substitute decision-making when you don't have capacity or someone doesn't have capacity to do it for themselves. The other part of that is a living will, which allows people to sort of pre-decide what sorts of treatment they do or do not want if they're in an end-stage medical condition or if they become unconscious in some way. So those are great tools, something to consider. Act 169 also allows for substitute healthcare decision-making for people who did not do that. So they didn't create a healthcare power of attorney or living will, or they cannot do that because they don't have the capacity to understand those documents and what they mean. So in that case, you're looking at what's called a healthcare representative under Act 169. And that person who's the healthcare representative can make healthcare decisions for an individual when their attending physician or doctors determine that they don't have the capacity to make decisions for themselves. If they're 18 years or older, or if they've graduated from high school, or if they're married or they're emancipated, that's the age and the way that they would now need a third-party decision maker. And they don't already have a legal guardian or somebody who's already authorized to make decisions for them. So they don't have a legal guardianship in place, or they don't have a power of attorney that they've executed. Or even if they do have a power of attorney, if that person's unwilling or unavailable, then you can also look to a healthcare representative. The great thing about it is a healthcare representative can make healthcare decisions without the need to go to court for guardianship. And even if the person is not able to execute a healthcare power of attorney. So it's a very good tool for families to have if they're looking for a way to continue to help support their loved one who's now transitioning to adulthood and still be in the picture. I think that's a big fear for families is once my kid turns 18, I'm going to be locked out of these decisions. Well, if your loved one is able to make their own decisions, then I think the role we heard this morning is you now become a consultant and part of the support network. But if you need to step in and make decisions because your son or daughter or your child is not able to do that, you can do that legally as a healthcare representative. So that's the beauty of that law and the thing I wanted to point out. I don't know how much I sort of lost track of how far I am down the road with my time. I don't want to take up too much more time talking about it, but I'm grateful that you've all come to listen to this. And if nothing else that you learned from today, I want you to remember that healthcare decision-making is something you can do without legal guardianship. It's something you can do without a formal legal document. You can call the Disability Rights of Pennsylvania, and we can talk to you more about that. We're happy to help people get pointed in good directions without actually having to go for guardianship. And again, we can connect you with other social services. So I mentioned a bunch of things at the beginning. You're now your child is ready to graduate. They're going to go into the adult world. They're either going to potentially go into employment, more schooling, or they're just going to try to focus in on their healthcare plan and start thinking about supports and services. All of those things require a team of people and a group of professionals, and social services and getting connected with those programs are really essential in transition planning. And I would say you should start doing that at least when your child is 14, start then, if not sooner. As we heard this morning, you can start from birth, but don't fall off that cliff. When your kid's about to graduate school, they're no longer entitled to all those services they were getting through the school. They need to connect with other social services. So I'm going to let Bob, and then we'll save time for questions at the end, but thank you for your attention.
Thanks, Shari. Wow, it needs to stretch. That's a lot to take on. Again, I'm Bob Corcoran, and I'm going to talk about some of the financial concerns around transitions. When Dr. McCormick first invited Shari and I to speak on this panel, he mentioned that this would be a TED Talk type presentation. And since I was rather unfamiliar with TED Talks, I did what any anal retentive bean counter like me would do. I started binge watching TED Talks. And I came across one that I thought was particularly apropos. It was The Secret to Mastering Life's Biggest Transitions by a gentleman named Bruce Feiler. Mr. Feiler interviewed thousands of people, and his conclusion after having done so was that we all need meaning, purpose, and joy in our lives. And I believe our goal today is to find ways to achieve that for our child with a disability as well as for ourselves. Mr. Fowler came to that conclusion by observing a couple of things. One, that we don't lead linear lives. We don't just have one job and oftentimes just one spouse or just one house. There are multiple things that we go through. In fact, in addition to the many decisions we make every day, his conclusion was that the average person goes through 36 transitions in their lifetime. And that applies to both your special needs child and to you. So no one's exempt from that, right? So I know the focus of our talk today is the transition from childhood to adulthood, but there are additional transitions that your child with special needs is going to face, right? It's not just becoming 18 and now you're an adult. It's you're 21 and in Pennsylvania, those supports you got through school, you've heard this multiple times today, drop off. And it's a cliff. It always catches people flat-footed. Another thing that catches them flat-footed is your child hits age 26. It isn't covered by your employer's health insurance anymore. There are multiple transitions like that, along with all the other stuff that anyone can go through, right? Perhaps they get married, perhaps they get divorced, perhaps they get a job, lose their job, find another job. For parents, it's all the above and their own incapacities, right? So you become ill. You're not suddenly bulletproof because you have a special needs child. You've got issues you've got to deal with yourself. For siblings, it could be becoming a caregiver. That's something that maybe they didn't necessarily plan on, but it's going to happen. So the challenge then, from my perspective, is to try to build an all-weather bulletproof financial plan that's going to stand up under the pressures of all those transitions, not just becoming adult. That's an important one, though, because now your child is going to be measured on their own resources. In Pennsylvania, you get an exemption for your minor child, but child's not a minor anymore. That goes away. So it's an important one. Another thing that Mr. Fowler pointed out was life transitions are a skill that we can and must master. Boy, I would definitely agree with that. By accepting your own emotions and dealing with the stuff that people have to deal with, right? I find in my dealings with families is procrastination is common. Rather than beat yourself up over it, I usually in the workshops that I do hand out these little wooden nickels with the letters TUIT on it, right? Because people will say, I'll do that when I get around to it. It's corny, but okay, now you have one. No more excuses. And seek wisdom from others. You've heard this theme today too, right? Seek wisdom from others like the folks here. Not just in terms of medical issues, financial issues, legal issues. There are people out there ready and willing and able to help you. Take advantage of that. You can't hunker down in a cave. And there is kind of this Alamo mentality that develops, right? That me against the world. It doesn't have to be you alone against the world. And be the author of your own life story and not just the subject of it. To Shari's point, that everyone should have a will. In my opinion, everyone should have a will. And if you don't have one, the state of Pennsylvania, like every other state in the union, will give you one. And it may not be what you want. So don't let somebody else dictate terms to you. Dictate your own terms. So that's a plate full, right? That's a lot to take in. I'm going to try to narrow the focus a little bit. As I stated earlier, we all need meaning, purpose, and joy in our lives. And I'm going to define that here as quality of life. Much of what you heard today was about lifetime care, the basics of food, clothing, shelter, healthcare, how to access it, who provides it, and so forth. And as critically important as that is, I want to address your child's quality of life. How you can make sure your child lives to be happy and fulfilled, that he or she achieves the meaning and purpose and joy that we all seek. With that being said, most parents would say to me, look, as long as we're both here, assuming there are two parents, as long as we're both here, we'll take care of our child. It's when we're gone that there's an issue. When we're gone, will somebody else care for my child at the same level, with the same love and attention that I will? Probably not, but there are some things you can do to mitigate that. Let's put it that way. Shari addressed the legal concerns. I'm going to speak more precisely about the financial issues. You may feel you have this covered. I already have an advisor. I already have a lawyer. I already have an estate plan. I've done all that. I'm going to tell you, again, from my perspective, special needs planning is unique. Some of the advice you might get in a typical situation that's totally appropriate is not appropriate in a special needs situation, because the key, the important aspect of it is maintaining your child's eligibility for government benefits. Everything else is secondary. Return on investment isn't that important. Minimizing fees, minimizing taxes, those are all important things, but maintaining government eligibility should be the driver. If that's not the priority, you're talking to the wrong people. In its simplest terms, maintaining government eligibility means, in terms of Medicaid and SSI, you're allowed to have essentially $2,000, a house and a car. Anything above that, and you're not qualified. And if you're relying on Medicaid, and not just Medicaid, but programs that are pegged to Medicaid eligibility, there are some out there, some programs that your child may benefit from that they can't buy their way into. They can only be admitted into some of these programs if they are Medicaid eligible. So maintaining Medicaid eligibility is important, regardless of your financial situation. Again, some of those rules are waived, at least in Pennsylvania, when your child's a minor, but at 18, they're an adult. They have all the rights and privileges of an adult, including the right to privacy. So it's none of your business if the hospital admits you're an 18-year-old. That comes as a shock to people. So you want to have these little bits of paper in place to make sure that your child will be cared for. And you also want to make sure that you don't inadvertently upset their continuity of care by violating Medicaid rules, by leaving money to your child, by having them hold money in their own name. There are ways to deal with that, right? The best way, the right way, is by using something called a special needs trust. Some folks will say, well, do we really need to do all that? Do we really need to spend the money on a trust? I've got two kids, one typical child, one with special needs, little Johnny, little Susie. Little Johnny's going to, quote, do the right thing. I'll just leave everything to little Johnny and he'll take care of little Susie. The problem is little Johnny could grow up and get divorced like more than half the people in America. And now his ex-wife or ex-husband, as the case may be, has entitlement rights to the assets you intended for your special needs child. Where little Johnny grows up and as he's driving down the road, runs a stop sign and runs into Bob Corcoran. And now Mrs. Corcoran has entitlement rights to the assets you intended for little Susie. So disenfranchising a child is not a good solution. we'll get into a special needs trust and what that looks like here in a little more detail. It's the only legal solution that will protect government eligibility, and it's got language in it that specifically says that it's designed to supplement, not supplant Medicaid. It'll do all the things Medicaid won't do and none of the things Medicaid will do. For one example I use, and it's a simple example, but Medicaid, if your child's in a wheelchair, Medicaid will pay for the wheelchair, but it won't buy you a van with a lift so that you can get your wheelchair from A to B. A special needs trust can do that. Medicaid is not going to pay for your child to go to Disneyland, Disney World, but a special needs trust can pay for that. So all the things that would enhance your child's life and make them happy and fulfilled can be done by use of a special needs trust. Let government benefits pay for the subsistence stuff they'll pay for, and use your dollars to pay for quality of life instead of using your dollars to pay for fundamental things that the government would otherwise pay for if you qualified, if your child qualified. So what kinds of trusts are there? Special needs trust can be designed, can be created by anybody, can be created by the special needs person themselves. That's a first party trust, or can be created by anyone else. If it's created by anyone but them, it's a third party trust. What's the difference? So in terms of the benefits to the disabled person, the benefits are the same. The difference is that a first party trust created by the individual, let's say because they inherited money. And I've got a couple of clients in this situation. They've inherited funds. In order to maintain their Medicaid eligibility, we had to put that in a trust. Medicaid has the right to be paid back for anything it paid out during that person's lifetime at their passing. And any remainder beyond that can then go to other family members. A third-party trust, on the other hand, does not create any Medicaid entitlement. So you can leave money to a third-party trust, and at the passing of that person, the remainder can go to other family members. So that's really a more efficient way to fund a special needs trust if you can. Sometimes you don't have a choice. Your child was, injured one way or another or inherited money. First party trust is going to be the only alternative. The other thing you might do if it's a relatively small amount of money, there are a number of organizations locally and nationally that operate pooled trusts. So for someone who doesn't frankly have the resources to go through all the foo-for-all of creating a special needs trust, can go to an organization like the Family Trust or Life Enrichment Trust or River Communities Trust here in the Western Pennsylvania area, and put those funds in a pool trust. And then the remainder, instead of reverting to Medicaid, would revert typically to that charity. What can go in? What can go in that trust? Well, virtually anything can be put in it. A home, financial assets, both non-qualified and qualified, non-qualified being non-retirement assets, essentially, right? But I find, I don't know about your house, but my house doesn't make me money, it costs me money. So if you're going to put your home in a trust like that, it's strongly advisable to also include some kind of asset that's going to generate income so you can pay the light bill and pay the real estate taxes and pay the bills that come along with home ownership. Any other kind of real property can go in there as well. So if you own an oil well in Texas and you want to put it in there, go right ahead. Financial assets can be a funding vehicle. Non-qualified, non-retirement accounts are fine. If it's currently funded, be aware of the potential tax consequences. A trust is a tax-paying entity. If it's depending on how it's set up, it may be created as a separate tax-paying entity, and it pays taxes at a higher rate than you do. So if you're not happy with your tax bracket, you probably won't be happy with your trust tax bracket. You can put retirement assets in a trust like that too, and for a lot of folks, that is their biggest asset. But you run into particular tax consequences there, right? Because typically, if it's a 401k or a traditional IRA, anything you withdraw from it is going to be immediately taxable at whatever bracket you're in. It's not necessarily an efficient wealth transfer vehicle. It's a great wealth accumulation vehicle, but not a great wealth transfer vehicle. You can also use insurance. And insurance, contrariwise, is, I would say, not as great a wealth accumulation vehicle, but it's a much more efficient wealth transfer vehicle. Because if it's designed correctly, it is not subject to inheritance tax in Pennsylvania, can be designed to be not subject to federal estate tax if that's an issue, and it's not subject to income tax either, again, if it's designed correctly. Insurance can be in the form of term insurance or permanent, whole life, universal life, variable life. It can be on one life or two. And a survivorship policy is something that most folks aren't really familiar with, but it's a unique vehicle that was created really as an estate planning tool back when the estate tax affected a lot more people than it does today. But we often find that it's a good fit for a special needs situation. Again, getting back to that point of, as long as we're both here, we'll take care of our child. It's when we're both gone that there's an issue. Well, that's when a survivorship policy actually pays a benefit. And because it's on two lives, not one, it's not paying that benefit till the second death. And as a result, it's typically less expensive than one policy on two individuals. So whether that's the right fit in a particular situation or not, depends on the facts and circumstances. Just be aware that there are other vehicles out there. I mentioned the different types of trusts, and they are typically the most effective way to put funds in an account. It can be funded by anybody. It can be funded while you're alive or at your death. Again, I have a standing agreement with all my legal friends. I won't practice law without a license if they don't practice financial planning without one. But just be aware that you can create a testamentary trust that's created at your death, but I can't fund your trust if it doesn't exist yet. Grandma, great Aunt Maud can't put money in your child's in a trust for your child unless it exists. So oftentimes we find an inter vivos, a living trust, makes more sense because it creates a bucket today that you can put money in today or in the future. Is that the right answer for everyone? I'm not saying that. I'm saying that it's a little more flexible because it creates a vehicle that exists right now. And it can be funded by anybody, and there's no limit to how much it can be funded for, as opposed to, say, an ABLE account. I hear this quite often. Should we use an ABLE account instead of a trust? And I would say not in lieu of, but in conjunction with. An ABLE account is a vehicle that's built on the same chassis as a 529 plan, if you're familiar with a college savings account. But instead of being for college expenses, it's designed for the needs of a person with a disability. There are limits to how much can go in. There can be only one. The annual contribution limit is pegged to the annual federal gift tax limit. There's an overall accumulation limit of, I want to say it's $100,000 still. If you get beyond that, you run into disqualification from SSI, if that matters. So it's got some inherent limitations, but it can do some things that are a little more flexible than a special needs trust. A kind of simple-minded example I use is a special needs trust, in theory, shouldn't pay for food. It can buy your child a ticket to the movies, but it shouldn't buy popcorn at the movies. But the ABLE account can. So there are some differences, some nuances between what those two things are designed for. In addition to all the legal documents that exist, there's another document that isn't strictly speaking a legal document, but we feel it's an important one. A memorandum of intent or letter of intent. Think of it like this. It's a note to the babysitter as if you're going to the movies and never coming home. Who else besides you knows that your child won't take their meds unless they're wearing their favorite red sweater? Who else but you knows which pediatricians you want to go to? No offense to the docs in the room, and which ones you never want to go to. No one knows that but you. Write it down. Give the caregiver, give the person who has it in their heart to take care of your child instructions on how to do it. And you can get a format for that from various organizations. I know Achieva has one. I know UCP has one. Our organization provides it. It's strictly an outline, and it's as free form as it needs to be. It costs you nothing but time to fill it in, but it's a critically important piece to the overall planning process. When it comes to funding a trust, how much is enough? What's the right number? That really depends on an individual, right? You're presuming that government benefits are going to pay for healthcare and, the basics, food, clothing, shelter. How much quality of life do you want your child to have? I don't know the answer to that. There are some guidelines, though. I've seen studies by one group in Pennsylvania that the average family spends out of pocket on average something like $16,000 a year out of pocket for stuff for their child. It's easy enough to do the math to say, well, how much would I need if my child lives to a normal life expectancy? How much do I need to set aside at a given rate of return, given inflation, blah, blah, blah. Is that the right number? I don't know what the right number is. You know what the right number is. You as a parent know better than I do. So, but you can build it to be whatever number that needs to be. It's important also, I think, that you inform other family members as to what you're doing so that somebody doesn't, with the right intentions, inadvertently undo all the hard work you did. You go through all the stuff that I'm describing and all the stuff Shari described, and grandma or great Aunt Maud leaves your child an inheritance. Now suddenly they have assets that they, instead of leaving it to the special needs trust for their benefit, they leave it to that person directly. That creates a problem. Let people in your family know what you're doing, and not because you're making any kind of demand, but just to share the idea that, look, if you're going to do something for our child, here's the right way to do it. Here's the best way to do it, and give them instructions. One further thing on the special needs trust, you can name anyone as the trustee, right? And when you have a trust, that implies there's going to be a trustee. It can be anybody. But I would tell you this from my standpoint, you can name an individual. Don't. My suggestion would be don't. For this reason. I think if most people understood what the word trustee means, they'd never agree to do it. It's a fiduciary obligation. I find that if you name a 25-year-old male as a trustee and fund a trust, they're going to invest the money like a 25-year-old male does. If it's a 75-year-old female, they're going to invest the money differently. And both those things aren't necessarily correct. It should be done in a way that's appropriate for the beneficiary, right? An organization, a corporate trustee, one that does special needs trust, is a better fit from that perspective, I would say. But you want a family member to be involved. And how do you do that? Well, somebody who has it in their heart to look out for your child can be a trust protector. That's another concept, without necessarily being a fiduciary, with the sole role really of saying, if the corporate trustee doesn't do what they're supposed to do, we're going to fire them and find one that will. That way and remember too, that the corporate trustee has to deal with Medicaid and all the filings that go with Medicaid. I'm a CPA, and I can tell you, I find most people aren't ready to do their own tax return, let alone file Medicaid reports. And you can have people that do that for a living do it. It just seems to make a lot more sense. Don't have to do it that way. You can name anybody, but you take pot luck when you do. With that, where do you find people that can do this type of stuff? It's not really all that common. There aren't that many attorneys, frankly, that do special needs planning as a part of their estate planning process, I would say. That's just an observation. There are definitely not very many financial planners, relatively speaking, and there are virtually no CPAs. I've been a CPA my whole career. It's just not something we're typically taught. But you can turn to a couple of national organizations like the Academy of Special Needs Planners for both attorneys and financial planners, the Special Needs Alliance for attorneys. There's some other national organizations like that that focus in this arena. I would simply say, when you're going to go to a financial professional or legal professional, the right question to ask is not, can you do a special needs trust? because the answer typically will be yes. The question to ask, it's like asking, can you swim the English Channel? I took swimming lessons at the Y. I could probably do that. Like, no. How many of these have you done? Are you active in this environment? And that's the right question to ask. With that, I don't know if any of you have any questions, or Shari, would you care to?
Can you tell if there's any questions online?
I see no open questions. So either we gave perfect information or just completely confused everyone. Please.
Well, here's the thing. Speaking to the mic to ask the question so that they can hear it online. So obviously the information you guys covered, thinking about legal implications and financial implications for transition, is a multifactorial and complicated process. And a lot of times when we talk with families, it can be all coming at them kind of in a moment when they have to do everything right away. So it can be overwhelming. So what would be, from y'all's perspective, from a financial and legal perspective, one thing that families can do as their first step? What is like one step you can do? Or as a healthcare provider, maybe we can flip it and say, what is one question you could ask your families to help promote them in this process to be ready to kind of walk through this? So from a family perspective, and then from a provider perspective, what's one step that you can instruct them to take?
My general philosophy is the perfect is the enemy of the good. So start somewhere. I'm biased. I'm going to say start with a financial advisor and ask some questions, get some basic building blocks in place. A financial advisor where the salt's going to ask, do you have a will, a power of attorney, a medical directive? If you don't, you need to get those things done and presumably can refer someone who works in that arena. If you have I think I mentioned this, if you have a 401k plan, you're the wife, you have a 401k plan, and your husband calls me and says, my wife was in a car accident, we need to draw money from her 401k. I can't talk to you unless you have power of attorney. So it's not just your child that needs all that, you need that. So go get those basic building blocks. If you don't have that, and I find if I polled a room, typically half the people in the room don't have any of those building blocks in place. Don't wait till there's an issue to have one. I liken it to having an umbrella, right? I'd rather have it and not need it. I'm not begging for it to rain. I don't want it to rain, but I'd rather have it and not need it than need it and not have it.
So I think I would say what's been said multiple times today, which is you need to start thinking about transition sooner than you think you do. So the first step is just to start talking about it and having conversations. I think it's hard to, I don't believe there's a one-stop shop for transition for families because there's just too many areas of life that you need to think about. So for your medical care, we've heard this morning and repeatedly, like start talking about transition and what's going to happen as your child ages into an adult system so that you can start taking the right steps, making connections with the adult providers and making those things happen smoothly. In school, you should be doing transition planning. If your child has an IEP, when they turn 14, they're legally entitled to start participating in those IEP meetings and start talking about what are their interests? Do they want to go on to college? Do they want to go into employment? What do they need to do? What kind of things do they aspire to be? Like start talking about those things in school with your IEP team. If your school has a designated transition coordinator, talk to that person so that you're covering that area of their life as well. It never hurts if your child has a very specific diagnosis. For example, like in the disability world, if your child has a diagnosis of Down syndrome, to connect with organizations that support families and individuals with that particular diagnosis, because they have often, through their own experiencing and networking, have developed a list of resources and ideas and places to point you to that maybe are more tailored to your specific situation than generic would be. It's also good to start looking into your county assistance office as your child is getting towards the adult ages, and you're going to want to think about when they're done with school, where do I get these support services? What's out there? County assistance offices are helpful for that. Counties have MHID offices in particular. If your child has that diagnosis of mental illness and or an intellectual disability or autism, some cognitive impairment, you can start there and they can start talking to you about what are the services and supports that you need? How do you get connected? How do you fill out the paperwork and the applications? Medicaid is going to be crucial for a lot of families when their loved ones transition to adulthood. They're probably going to need some public assistance, and Medicaid is really helpful for making sure that healthcare needs, but also other community integration type needs, becoming a productive adult, and the supports and services can be connected through waiver programs. And so you're going to want to learn about those sooner rather than later. You don't want to learn about them when you're falling off that cliff because your kid's graduating from school and now they got nowhere to go. Right. So you want to start thinking about that early. And I'll make one last plug. You can call the Disability Rights Pennsylvania. We can hopefully point you to the right direction. We can talk to you about any issue that's disability related. And again, even if it's not something that we can give you specific advice, we can help point you towards other resources that you should connect with to help that transition go smoothly.
The question I have is, how long does all of this take? If I'm a caregiver of a young person and I have none of these supports in place, if I started today, at what point would I have a trust set up? At what point would I have the legal paperwork for supported decision-making or guardianship done?
Want to answer that? From my perspective, that's on you. I mean, we can do the paperwork very quickly. What I find is parents procrastinate. I've had people attend workshops I've done and call me 3 years later. It's like, yeah, we were thinking about what you talked about 3 years ago and we're ready now. So it's getting over that inertia of parents that drafting a document is easy. If you know who you want the beneficiaries to be, you can name the right parties. Most attorneys can turn that around very quickly. Financial advisor can do an intake meeting, and if you give me all the information, I could do an analysis within a week or two of where you should start. The problem is going to be, the problem I face typically is, again, the inertia of parents. Do we really need to do this? If I create this thing, am I somehow restricting my child? I get that a lot. And I would say, I try to encourage parents, it's the other way around. We're trying to give your child as many opportunities as possible, not restrict them in any way. What if I don't need this? Okay, your child's cured somehow down the road and you don't need this? Fine, you spent a couple of $100 or $1,000 on an attorney to draft a document you don't need. You don't get to open your umbrella. What a shame. If that's the worst that befalls you, how bad is that?
So with regard to healthcare decision-making, which I spent my time talking about, and the forms that you can use as alternatives to guardianship, which is healthcare power of attorney, living wills, and a healthcare representative form. There's really zero time at the front end. These are pre-existing forms that are legally compliant and they're easily accessible to families. You can get them online. We have on our website a healthcare representative form that you can use as a template to be a healthcare representative. I think the Allegheny County Bar Foundation had put out a pretty comprehensive healthcare power of attorney / living will combined document that's readily available and free for families to download and use. You can meet with an attorney and draft something, but honestly, these forms are compliant with Pennsylvania law, so you don't really need to do that. So that part is not, that can be done relatively quickly. Like Bob said, you just have to sort of decide, is this the right tool? Is this the right fit? Is this going to solve the problem that I'm facing? And we can help talk you through some of that. Sometimes there is a form that's pre-existing that's really easy to complete that's going to help you right away. If it's a little bit more complicated or a little tricky, maybe it takes a little bit longer. And certainly guardianship would be the longest process because you have to file a court petition. You have to file a petition in court to ask the court to award guardianship. And you're most likely, there's expert forms that have to be completed so that they're basically attesting to the fact that the person meets the definition of being legally incapacitated. So that's a longer process. It's could take a while depending on, if you're going to hire a lawyer and then get a petition drafted. Those things vary, but that's why I always say it's more time consuming and more costly to go the guardianship route when there's much easier and quicker solutions potentially for your individual situations that could help in some cases.
All righty. Thank you.
Maybe send education your way.
Uh,
Oh, like I have like fiscal year somebody on our webpage there's listing all the staff and you'll find it there, and we also have like that 1-800 number that you can just call. Okay, every day we try to answer live between 9 and 3, and that means the way to reach me or just I leave that card.
Yeah. You both very, very much. It's really informative.
Thank you
Well, I
for
was-
coming.
Yes, yes.
It's great. You said yours is 13.
Yes, yeah.
Oh, thank you.
Oh, yeah, yeah. Well, and it's because of the way the Down Syndrome Center is set up. We started with the Healthy Transition Program this year, so we start.
I should answer this question that way, that where to start with the support organization, because they can point you to people like Shari, like whoever, other families have been through what you've been through.
Yeah, just connecting with people who get it, is really, really helpful. Yeah. Yeah.
Well, thank you very much.
Thank you. I am.
Wow. Oh,
You sing like a page, but I don't know.
I gave you one page on your,
I need to clean up after myself,
there was one straight. I see.
One stray page. Like, I don't wanna leave my garbage.
Boys Scout, campground and farm. I think there was just the one I picked up, I think that I gave you.
Yeah.
So, what did you say?
I think, I find these things are wonderful, and I'm glad that the hospital does it, but I feel like I wish we didn't have the computer thing, like remember I said to you, simply if we just had like a few people, we could just sit down and be much more interactive instead of like giving the presentation, that would have been nice, but
Especially since we don't know how many people are actually online, was it 1 or was it 100, I don't know.
don't know. I mean, I don't know if they have a way to count them. Like if there's a registration or a track, like, because I think people have to click the links to join, so maybe there's a tracking.
What did they register? I don't think that's how they set it up.
I don't know about you, but since we report, when we do these types of things and we report to our funders, like, hey, we did this, I'm counting everybody who registered.
Well,
I don't care if they were in the session, but.
Once I'm supposed to provide a list of
Right. Oh, it's a
acres. Well. I didn't push that, but then I didn't want to make an issue of it, but I get pressure to do that, right? Because they would be sure that I'm not saying something untoward. You know, like guaranteeing results or blah, 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 so. Yeah.
I'm gonna make you a millionaire. What is now, billionaire? I don't know if millionaire cuts the mustard now.
More or less. You say March?
Is it? I'm scared. I think there's another section. Or
March, there's no, you're right, here's like a. Kios, I guess.
yeah, from 11:30 to 12, so we should stay for that. I don't know, I wasn't sure about lunch. Are you gonna stay?
I thought it would just, I wasn't sure who all would hear, but just,
Yeah, I thought, especially if there were like a lot of people, I was like, well, we could stay and talk to them, but
right,
it depends on who's left, I guess.
yes. Point. That, we're all stuff.